Today, we're addressing a deeply important but often overlooked estate planning question. How do I protect my children's inheritance if my spouse remarries after I pass away? It's a scenario that can introduce emotional complexity and legal risk if the right steps aren't taken in advance. While none of us want to imagine leaving our loved ones behind, thoughtful planning today can safeguard your legacy and reduce the potential for conflict or unintended consequences later. Today, we'll walk through 5 key areas to consider so your children remain financially protected no matter what the future holds. So Spencer, today we're going to dive into a complex estate planning topic. How do you continue to protect your children's inheritance if a surviving spouse remarries after you pass away? So this doesn't apply to everyone, but let's talk first about who this could apply to. You want to walk us through that first scenario?
Well, one of the groups of people that this would tend to apply to is blended families. So if you come into a marriage and you have children, each spouse has children, let's just say the spouse who passes away first may want to make sure that his or her son, daughter, children receive some portion of an inheritance, that they are not disinherited by the surviving spouse who may not have quite as much attachment to them. So that's one scenario. Another scenario could be when we have a significant age difference in the spouses, maybe 10 years or more. So if we have an older spouse and a younger spouse, and the older spouse says, well, if I pass away, will my younger spouse remarry and potentially make financial decisions that are in line with what I'd like. So that can be another situation where we might see that older spouse want to put some protections around resources going to children, if especially there's a significant estate there. A third situation might be if we have a strained relationship between one spouse and children, and maybe not quite as strained a relationship with the other spouse. So let's just say mother has a great relationship with kids. Dad doesn't have as great a relationship with kids. Mom may say, hey, I really want to have something in place where if I predecease you, that those assets are going to go into a trust, at least her assets go into a trust, so that they will maybe help the husband for a time, but also be directed to her children thereafter. Another situation would be if we have one spouse who has some cognitive impairment, or maybe they're just not a financial person. Finances are difficult for them, and maybe they're prone to make decisions that are not as strong. Again, in that circumstance, the spouse that tends to handle the finances may say, well, if I predecease this spouse, I may want to have a structure in place that would protect the spouse that's receiving the resources, but also protect an inheritance, just so, again, poor financial decisions might not be made. And then finally, if you have a multi-generational legacy that you really want to protect, or perhaps a child or grandchild that has special needs, you may want to have something put in place such that the surviving spouse maybe doesn't make decisions that would make that goal be in a situation where it might not be fulfilled.
Right. Okay. So let's talk about maybe situations then where it's not quite as critical, or not quite as urgent to put protections in place.
Well, if you and your spouse have children, your heirs are with you together, biologically, and if you're in alignment in terms of core values, then that oftentimes, if there's not friction in relationships that's significant, and you have alignment in terms of the family tree, then there's less need to go this path maybe. Also, if you've already gone through the process and within your core estate planning, you've already addressed this issue, then you wouldn't need to necessarily come back and readdress this issue, especially if you're using a trust or a series of trusts there. And then the final one would be if the spouse who's likely to survive is the financial person and perhaps isn't likely to remarry. That would be another set of circumstances where you might say, well, we're not sure that we need to go that direction. So there's a lot of folks that this won't apply to, but for the folks who do, they may want to at least take a look at the different options that they have to be able to get everybody in alignment. The key thing, and we'll come back to this at the end, the key thing is that you actually think through this, have the conversation with everybody involved to express your intentions.
Right. Okay, so you said the T word a couple times.
Yeah.
Trust.
Mm-hmm.
Talk us through why using a trust makes sense here.
Well, in each one of these different situations, if being able to protect some resources and clarify intentions is helpful, a trust is going to put that plan in place in a way that is basically irrevocable, at passing. So a trust, you could put together a revocable trust during your lifetime. Then when you pass away, it becomes irrevocable. That is, you're not going to walk that back. And so you're able to speak beyond the grave. You're able to make sure that that surviving spouse has what he or she needs, and then that the children perhaps get the remainder of those resources. So that can be really helpful in protecting your intentions. It can also shield assets from being commingled. So let's just say that surviving spouse, he or she remarries, and maybe the decision seems fine up front, but let's just say then there's friction with that spouse. Well, if you've commingled those assets, all of the assets from the first marriage into the second marriage, well, now we might have a significant issue. So it can shield assets from commingling if we have some assets, at least, that go into a trust that are used for the surviving spouse, but are not owned by the surviving spouse. They can't be commingled there. And then the final thing would be, a structure like that, a trust, can enable staggered distributions where surviving spouse could have resources, on a year-to-year basis, may have more at certain inflection points, but also you can speak beyond the grave to your children's situation, and maybe they receive a lump sum at certain times, or they have, income year to year, or what have you there.
Okay, so our second part, we're going to talk not just generally about a trust, but one specific type of trust, a qualified terminable interest property trust, or QTIP. Can you talk us through a QTIP? Yeah,
so a QTIP basically just sets things up where there is an amount that goes into this trust that usually is fairly significant. The income from that goes to mom or dad, whoever the surviving spouse is, can be used by them, usually for living expenses. But the principal ultimately is going to be passed on to the heirs. So that can be one situation where if the amount of assets is kind of right, then you have enough to be able to take care of surviving spouse, but you also are protecting the next generation to receive something down the road.
Okay. So let's talk about maybe the third idea. You could update your beneficiary designations. This really needs to be done carefully. Why would we want to update beneficiary designations instead of using a trust?
Well, you would want to update beneficiary designations in concert with using a trust. So typically what we want to do is we want to make sure that any assets that are earmarked to go to one beneficiary free and clear, so let's say surviving spouse receives some of those resources free and clear, that's great. But just know that surviving spouse then can make decisions whatever he or she wants to do with those resources. So if we have a beneficiary designation that we're updating, we want to make sure that those assets that need to go in that direction do, but that we also have beneficiary designations in place that may go to the trust. So if this is an IRA or a 401k or even an unqualified account that we want to push directly to the trust, then the estate plan needs to be tight enough to do that. We need to make sure that people understand that those beneficiary designations, particularly those that are IRA, 401k, those types of beneficiary designations, that sometimes they define where the bulk of the net worth is going for a couple. If they stay moving to the surviving spouse, as oftentimes they're written for, 15, 20, 30 years prior, if they're not updated to go to a trust, then that's going to supersede anything that you have in the will.
Right.
So you need to make sure that those beneficiary designations are updated if you want those retirement assets to actually be held by the trust.
Right. Okay. So let's talk about the next key point, using a prenup or a postnup. This is something we've talked about frequently, but it can be helpful. Why don't you talk us through the benefits of using one of these agreements?
Well, and particularly this is with blended families, not so much situations that would be rather straightforward. But if we have a significant inheritance coming, or if we have a set of circumstances where we have children from one marriage, children from another marriage, we've got a blended family coming together, this can be really helpful because it's going to clarify asset ownership. It's going to say, even though we have mom and dad coming together, if mom has received significant inheritance over here, she's not bringing that inheritance and commingling it with dad over here. There's a set of expectations there that, heaven forbid, something happened and they split. Mom's assets are going to stay with mom that she's brought to the table, and then by extension, they would be distributed to children that she might bring, to that marriage if it's a blended family. So it also reduces, of course, the risk, I should say, of legal challenges, which can be quite helpful too. Everybody should be on the same page. There's a level of conversation that's happened, whether that is before the marriage or even after the marriage. So you can have situations where you don't actually have a prenuptial agreement, you have a postnuptial agreement. Maybe it was overlooked and attorneys say a few months into the marriage, hey, you understand that you're going to be receiving an inheritance, or you've already received an inheritance. Let's make sure that we actually clarify what's happening there. So that can be actually quite helpful. And of course, these can support the existing estate plans, because if everybody knows where the assets are going, then the end of life decisions on the estate can also be clarified there too.
Right. And you mentioned this at the start, but our last key point is just communicating your intentions clearly with all parties.
Right.
Talk us through, obviously this is going to reduce misunderstandings. It's going to allow, we come back to this often, this idea of clear communication, whether it's gifting, inheritance, anything that we do, we want to communicate clearly. Why is this so critical in this situation?
Well, we've got complexity here. We said at the outset that these types of trusts, these types of estate plans, typically they're used when there's a level of complexity. So we want to make sure that up front, when we put these in place, that we're talking with all of the different parties involved. Now, there may be estrangement, in relationships there that you can't have a conversation, but typically you're talking with all of the people that you're putting in place an authority. So the trustee, an executor or executrix, a power of attorney. You're giving all of these people guidance on what your intentions are, such that they know with clarity, if push comes to shove, that this is what you wanted, and this is why you've set things up the way that you have. So for instance, let's just say that you set up a QTIP to be able to protect a spouse who may not be great with financial decisions. So, and it could be a spouse that's younger or older. There are situations where you would want to have a QTIP in place if it's a younger spouse that maybe hasn't made many financial decisions, or it could be an older spouse who's you're seeing cognitive impairment, come on with that person. So if the other spouse passed away prior to that, you wouldn't want to maybe give all of the decision-making capacity to someone that is seeing, cognitive impairment increase. So if we look at communicating across all of those things, at least your trustee, at least your heirs will understand this is why we did what we did.
Right.
It wasn't to be mean to dad, wasn't to be mean to mom. No, it was actually to be fair and to have someone in control of the decisions that's actually going to do the right thing, which can be hard to convey, but is really, really an important conversation.
Yeah. And we come back, and this is not about distrust. It's about honoring the decisions and the desires of that initial spouse. And I think anytime we think about these estate planning conversations, we come back and say, we are not estate planning attorneys.
Right.
And you really need to do this in concert with your estate planning attorney.
Exactly.
And then if your estate planning attorney suggests updating your beneficiary designations, guess who has to do it? You do. You have to go make those changes, make those updates. So always talk about this with your financial advisor. Talk about this with your estate planning attorney. Consider if this makes sense for you. It doesn't make sense for everybody. Before we close out today, Spencer, anything else you would want to say? All right. Well, we hope you enjoyed this episode, and until next time, take care. If you like these financial planning videos, please share with a friend, and if you have questions, go to our website at seriousretirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at seriousretirement.com. The information in this recording is intended for general educational and informational purposes only, and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.